Thank you, Mr. Chairman, and thank you for that great outline of why we're here today. I think over the several decades, Congress has held dozens of hearings about the Social Security Administration and its management of retirement and disability benefits. This oversight is important since traditional Social Security and Social Security disability are critical and important programs that impact people all across the nation and in North Dakota. Since I took office in 2013, literally hundreds of North Dakotans have asked me for help in navigating the Social Security programs. It works out to about 5 new cases every month. Many of these individuals are seeking help with the appeal of a disability claim. Others find themselves subject to overpayments or caught in some other kind of bureaucratic struggle. Nationwide, there are over 1 million people awaiting a decision or hearing by the Social Security Administration. These millions of individuals find themselves caught up in the bureaucracy, struggling to find a correct path forward, whether it's submitting the correct medical proof or understanding the disability program rules. It's critical that today we keep these citizens in mind. Our interest today in the big and complicated subject of Social Security disability is relatively narrow. We want to learn about the Social Security Administration's proposal to shift certain non-disability appeals away from the realm of administrative law judge hearings to proceedings presided over by the administrative appeals judges and attorney examiners within the agency's appeal council. This proposed action has raised, I think, very serious questions about whether this change will accomplish what the Social Security Administration hopes to achieve, and most importantly, the impact of this policy on the thousands of Americans seeking appeal from these decisions. I look forward today better understanding the difference between ALJ and attorney examiners, as well as the changes the Social Security Administration faces in managing competing needs and challenges. I want to fully understand the rationale for this change and, most importantly, get clarity on how claimant due process will be affected if this plan is implemented. Those who are familiar with the work of this subcommittee know we're interested. In fact, it's charged with the responsibility of improving efficiency, transparency, and effectiveness of our federal government. This hearing provides an opportunity to discuss how this proposal meets those standards while ensuring the integrity and fidelity of administrative appeals decisions. Finally, given the important role that the Administrative Procedures Act plays in much of this subcommittee work, I welcome testimony that illuminates how and why independence conferred upon ALJs by the APA should be preserved or enhanced. And that's a critical question here, because it seems that we have taken a turn and deviated from what has always been the norm. When you make a change like this, especially when it involves due process under law, the only opportunity that someone has to present their case, impartiality, the fact that you should have an opportunity to not be judged by people who probably already were part of a system that judged your claim. It is a troubling set of facts, but my mind, I think, remains open to better understand how we can improve efficiency but not take shortcuts on due process or on the rights of citizens of this country, especially to critical programs like the Social Security program. So thank you again. I look forward to your testimony, and I look forward to this committee's discussion after your testimony. Obviously, we're concerned about taking a process that we believed was required by law, which is an independent ALJ, and now doing a process internally that draws upon some of the folks who have already done the informal kind of adjudication, which was unsatisfactory, right? You have an informal process where you review these and obviously have denied benefits, resulting in the need for an appeal. That's where we're at, right? So what we're trying to get at is, are these same people who are involved in this informal process of determining appeals going to be the ones that sit as a fact finder for what could result in an appeal to the federal district court?
No, they're
Okay,
not.
so good. That's what I need to know, because we're trying to figure out why you're doing this. We understand that you're in crisis. I mean, when you have this many appeals pending, I want to know, in your decision-making, what was the matrix of ideas that came in, and why didn't you choose an idea that would beef up the ALJs, whether you go back and find some retired, Article 3 judges, whether you go back and find retired ALJs to come on to amp up, the ability to do this, working with OPM. I understand the OPM process, and we don't want people classified as ALJs unless they're clearly qualified. But by the same token, we don't want people deciding cases unless they're qualified. And so why do we think we need this level of qualification for an ALJ, but have someone within your agency doing these tasks without the same level of qualification? I think we're buying ourselves. I think our concern here is, number one, to understand your decision-making, and I applaud you. The last thing we want to do here is tap down creative thinking making on how we solve governmental problems. But we also don't want to buy ourselves a bigger problem. And I think that the chairman in the front end here talked about, the potential for a class action, the potential for appeals, more appeals to the district court, which would in fact result in more resources being utilized and more time in the appeals process. And so what were the alternatives that you examined coming to this decision to make this change?
Thank you, Ranking Member Heitkamp. So one of the things that I think is important for me, when I came into this job, I was asked to look at the challenge that faces us and what can we bring to bear to address it. As I've said in my testimony, both written and oral, this piece of the plan is a small part of our overall plan. There is no single, silver bullet or solution.
But you have to admit it's small but controversial.
Absolutely.
So you're taking on a lot of water for something that you're calling small.
But I do think that it's important for me to say we're looking at business process changes. A number of the business process changes in our plan are about how can we best support our decision makers, our ALJs, so that they can do only what they can do, which is conduct hearings and issue decisions. We are looking at a lot of IT innovations, a lot of changes, how we can move out manual work and paper workloads, how we can manage or how we can leverage video so that we can erase service imbalances from state to state, which there certainly are, as I talk when I look at wait times.
But when the public says you made a decision to hire your own judges, it seems like I would say, the system's rigged.
Yeah, I don't think that that's actually the case. I mean, the rigor with which we look to hire administrative appeals judges mirrors the rigor in my mind.
Then why not hire administrative law judges?
But I think that's part of the
that's the problem. You can't come here and say we're gonna do this, and de facto they have the same qualifications, the same ability, and the same independence as an ALJ. I go back to them. Why not hire ALJs? I mean, that's the disconnect for us here.
But I think that we aren't adopting one construct over another. I mean, our plan calls for aggressively hiring ALJs. At the same time, we are utilizing all of our other strategies. I mean, to hire ALJs...
I don't think you're answering my question, and I don't mean to be combative. I came into this without a strong opinion one way or the other, and recognizing, because as I said in my opening comments, this is something that I do consistently. Our office spends a lot of time dealing with your office on appeals. People, especially elderly people, struggle with process. They struggle with understanding the bureaucracy. We help them navigate that. We get great responses from you. So I didn't come to this, but I keep hearing the same thing, which is we aren't taking shortcuts. It'll be impartial and independent. They'll have the same qualifications. The appeals rights won't be violated because we'll keep an adequate record. Then I keep going back to, if you can find people who can do that, who have the level of qualifications, Why can't they be ALJs? Why do we have to have this hybrid, risking the potential for, a lot of mischief later on?
So again, I think that from my standpoint, it is a matter of timing. I mean, we are hiring as many ALJs as we can. I will give you an example, though, from 2015. We plan to hire 200.
I get it, that you can hire faster than you can through the process of OPM.
But we haven't set that process aside. We're trying,
I get that, but why can't we amp up the OPM process so that there is more, these same people who you say are qualified to do this, or looking at kind of how do you clear this backlog? And so I think, Mr. Kennedy, the question comes back to you. Do you believe that OPM can meet the needs of Social Security as they're looking at trying to take care of this backlog and do their job? I mean, I'm sympathetic to them.
Thank you, Senator. We are confident that we have the number of candidates on the current register to meet agency projections as we know them.
No.
But,
Let's assume that she now tells you she wants to hire ALJs instead of going the route that she's committed to. What's your role, and how do you meet her needs in providing a pool? She's already explained that, the numbers get skewed because somebody applies for 5 different positions, so you count them 5 times in the numbers. That's not helpful to her. It's not helpful to us to understand this problem.
Thank you for your question, Senator. In March of this year, we added additional names to the register. We released the new re-administration of the current exam, and we will be adding additional names. That will take some time because the process is a really detailed and structured process to get through. We will be also meeting with SSA later on this month in our innovation lab to think through other creative ideas of how OPM and SSA can work together to meet their backlog. We take this very seriously.
Yeah, but I think she's telling you that she doesn't have enough qualified people in the pool that you've sent in order to take care of her backlog. That's what she's saying. And so they're turning to an alternative method. And if that's not the reason why they're turning to an alternative method, then we really have a lot bigger discussion here.
Senator, I think that's something that OPM and SSA are working through. OPM looks at the examination process that we put ALJs through. It is potentially the most comprehensive examination in government, and we feel those who come through that process are extremely qualified. We do know that Social Security Administration has some concerns, and we want to sit with our colleagues and make certain we better understand that to see what we can do in the future to support our colleagues.
And it would suggest that you guys are concerned about litigation when you're trying to privilege that information. If it's just legal advice, then why privilege it? The taxpayers paid for it, let's see it. You said in your testimony you always had authority. We now have a legal brief in the testimony here that you don't have the legal authority. That's a foundational piece for us to understand in oversight. And so we haven't even talked about that. We start from the beginning. Is this legal, what you're doing? And are we buying, like the chairman said, a lawsuit? We have a difference of opinion. We have one, and the only person who has presented any kind of argument, and obviously this is in court of law, but the only person who's presented any argument is Ms. Zahm. And so, we need to know what your legal in order to do our job of oversight, we need to know what your legal justification is so we can evaluate it here. Otherwise, we'll draw our own conclusions on what your legal authority is. So, and we may only consider the evidence in front of us, and that wouldn't be good for you because we don't have yours. So
can we get it?
Yeah.
So I just want to make sure that I'm clear. In attachment C to my testimony was a summary of our legal analysis, and I know
Right,
that that staff had, I think, late last week met with your staffs to talk where we had our Office of General Counsel. I mean, I would be very happy to, set up any sort of additional setting where we can go at length through the legal analysis. I mean, our point of view is that, and our legal analysis is that we have had long-standing regulatory authority to vest the Appeals Council with these functions.
Does that include the duplication that Ms. Gruber's talking
No,
about.
this would be 600 individuals.
Individuals.
Yeah.
And geographically dispersed.
Geographically dispersed. And one thing I want to say, because I want to make certain that everyone understands that SSA and OPM are working together. We are trying to make certain that we typically try to give at least 3 names for every vacancy. SSA brought it to our attention a few months back that, guys, we need to make certain we're doing a better job on the unique names, and we are trying our best to make certain that we're responding to provide more unique names. Again, I think that everyone understands that SSA is just in an unprecedented situation. And I think the more we talk with SSA, the more the two organizations work together, we're going to remedy this. This is important for both of us. We are going to remedy this.
But we do not want the inefficiency of starting this whole process when we could, fix the one that we have. I think that's really the challenge. And the chairman outlined, we're taking on a lot of work, a lot of training, a lot of folks here on a temporary basis. If we could just get to making this process that you have work better. I think the question becomes, where do we go from here, Mr. Chairman? Obviously, we hope that this Oversight Committee hearing has at least raised some flags within the Social Security Administration to maybe, slow down implementation of this idea, to think differently, or at least have this ongoing discussion. I mean, we can talk till we're blue in the face, but if your decision is we're going to proceed, for us to try and do something here to stop you from proceeding, let me tell you, that's a difficult thing for us to get done. And so I'm curious on where we are today. Are you, gung-ho, we're going to get this done, we're going to move ahead, or will you kind of take a pause here with us and help us better understand this?
So,
Or find a way to get more ALJs.
Yeah.
yeah, I think, as I said in my oral, and it may sound silly, I mean, it is about capacity. I mean, my history is working with the disability process. One of my first jobs in the senior executive service was to look at a backlog at our initial level, and how do we increase capacity? And some of the solutions weren't popular ones, but certainly at the end of the day, my job is to make sure claimants aren't harmed. And that is my absolute commitment. And I think the issues raised here, the issues raised by Judge Zahm, are ones that I will take back and look with my team very closely at. I do think, and I apologize that, we have not given you insight, deeper insight into the legal analysis we've done. I myself am not an attorney, but the summary we gave, for me, laid out the regulations that really flow from the Social Security Act. And nowhere in the Social Security Act, in Section 205 or anywhere else, does it talk about the type of decision maker that must preside at a hearing. But I understand, we certainly, longstanding, have used a practice where we use ALJs. That said, I would like to find a way to, meet with you.
I guess what I'm saying is we would prefer that you hit the pause button on this idea so that we can better understand the oversight, better understand where you're at, and have further conversations about this. Yeah, I guess you're going to hit the pause button so we have a chance here to kind of vet this further.
So, I mean, I think it's a very fair question. As you know, we haven't implemented. We are, part of, what we're doing is vetting, and I think that this is a significant discussion, and I'm very, very willing to engage in additional discussion.
Yeah. And thank you for that. And in no way do I want to even suggest that we shouldn't be looking at creative ways to do this,
Right.
that we don't appreciate the difficulty of your job, and that you really have presented very appropriate testimony here today. We just don't have a comfort level, both legally and in terms of due process, with the direction you're taking. And we don't have a comfort level that we've really explored all potential opportunities for going the traditional route. Right. And so thank you for your testimony today. It has been very, very helpful.